same way as I think it's
Right.
Yeah, so it's like-
Stay with call Kayla Anderson.
So we swear from the testimony you're about to get the truth, the whole truth, and nothing but the truth, so help you God. That's it, it's not close to it.
Good morning, ma'am. What is your name?
My name is Kayla Anderson.
Miss Anderson, are you employed?
Sorry.
Are you employed?
Yes.
How are you employed?
I'm employed at the Chattanooga Police Department.
What do you do for the police department?
I am the Crime and Intelligence Analyst Supervisor there.
Okay. How long have you been the supervisor of the Crime and Intelligence Analysis Unit?
For 3 years.
Okay. How long have you been in that field in general?
7 years.
Okay. Did you require any sort of education in order to obtain that position?
Yes, sir.
What was that education?
That education was a bachelor's degree in criminal justice, a master's in business administration and data analysis and information technology.
Okay. As part of your role, are you a part of any professional organizations?
Yes, I am. I'm a member of the International Association of Crime Analysts, which is the national standard for our field. And then I'm also NCIC certified through the FBI.
Okay. What does it mean to be NCIC certified?
NCIC certification means that we can pull up records across the entire nation within the National Crime Incident Center through the FBI.
Sure. And you mentioned the IIACA, I think is what it was. What is that?
It's the IACA. It's the International Association of Crime Analysts.
Okay. Is that an accrediting body?
Yes.
Okay. And I guess my question backing up, what does the Crime Analysis Unit do?
Crime Analysis Unit, we specialize in support to the entire department. We are in the intelligence division within the department, but we assist with special operations, criminal investigations, anything from patrol level all the way up to the chiefs or even the mayor's office we get requests for. So our main role and responsibility is to find patterns and trends within crime and also to provide crime statistics as well. So we provide support on all levels for anybody within the department.
Sure. So finding trends out of the data for crime, that's basically what you've been doing for the past 7 years?
Yes.
Okay. In order to do that, what sources of data do you have access to?
The sources of data I have access to are the Chattanooga Police Department's records management system, otherwise known as our RMS. We also have access to the Hamilton County Computer Automated Dispatch records, which is known as the county's CAD system. And then we also have access to the Tennessee Integrated Traffic Analysis Network, which is the statewide system for traffic crashes.
Okay. That traffic analysis network, is that sometimes called Titan? Okay. And you mentioned a CAD report. Can you go into detail? What is a CAD report?
A CAD report is a summary of the call that came in via dispatch from the caller, but also what occurred on the side of the police department. So it's comments within the CAD card of the events that occurred within that call.
Okay. Are those comments made contemporaneously with the call?
Yes.
Do you have the ability, I guess, to do a word search of both police reports, CAD reports, Titan data, so on and so forth?
Yes.
Okay. So this summer, did I request that your unit perform some data analysis?
Yes.
Okay. What was the nature of that analysis?
That nature of that analysis was to keyword search road rage
Objection.
within.
Objection to any information, any evidence introduced in this sentencing hearing on road rage.
Why?
Well, Judge, there's been no proof of road rage that's been attributed to Mr. Vega in this case. The evidence don't support that trial. Was never, I mean, there's not.
It's not relevant. I'm sorry, I didn't catch up. Let's make sure I understand the basic.
It's not, I'm sorry, yeah, it's not relevant. It's not relevant to the sentencing hearing, Judge, because this road rage was never a part of this, the evidence does not show at trial that Mr. Vega was attributed, his actions was involved, that he alone had exhibited any kind of road rage characteristics.
Let's see where to begin. We could, of course, look at this as the defendant's memorandum calls it as perhaps an improper lane change, I guess, is how they phrased it in their memorandum. I would submit to you that no. What you had was testimony from the witness stand, specifically from an expert witness, Joe Warren, that the defense maneuver was, quote, consistent with an attempt to cut another driver off. Those are the words he used on the stand. Cutting somebody off would be a form of road rage. You have Dr. McGinty's testimony, who testified that there was this angry look that the defendant was giving him. That, combined with the context, which the state cannot ignore, which is the defendant is apparently cut off by Dr. McGinty, is what it appears to show on video. He then chooses to change lanes to ignore a lane closure sign in order to get next to Dr. McGinty. They both accelerate rapidly from the Woodland Avenue traffic light. Defendant makes this cutting off maneuver. And then, of course, he's angry after the wreck, not sad, not in shock, angry, cussing at people. In the context of that, the state's entitled to reasonable inferences of the proof, and this idea of, oh, it was just a bad lane change, that's been rejected by the jury. So I would submit it's relevant.
Judge, I can go all the way back to Red Bank when Dr. McGinty began his driving that day, but I'll do that later. But for the purposes of this, the two were at the red light. Before that, there's no indication of any kind of road rage. None. On either party. At the red light, at the Woodlawn red light, we see a video from inside the store. And Investigator Mullen, actually, I asked him on the stand, did you see anything going on during that time? No, there's nothing remarkable there. Both cars do accelerate, as all cars do when the light turns green. And Mr. Vega pulled ahead. Mr. McGinty said that he saw the defendant pull ahead, the man pull ahead, he hit the gas, he sped up. Now, that is road rage, in my opinion, but there's no evidence that Mr. Vega had any kind of road rage at all. And so we are to look at two people in a driving position, one in the right lane, one in the left lane, and Dr. McGinty looks over and he sees Mr. Vega looking at him. Well, Dr. McGinty is looking at Mr. Vega. So I'm not sure what, I mean, there's Dr. McGinty admitted that there was nothing else happened during that traffic stop. Not traffic stop, but the traffic light. No physical movements by Mr. Vega, no hand gestures, no body language. He was just looking at him. They were looking at each other, and that was it. And then Mr. Vega accelerates. He's going to move over. Dr. McGinty knows he's going to move over, and he stops by speeding up and hitting him. And that is the simplest way I can define what happened at that red light. No evidence at all that road rage occurred in Mr. Vega's brain. Now, after the accident, when he's sitting on the sidewalk, he's stunned. He's been injured. You see the building 50 miles an hour, that's testimony. He's stunned. He's hurt. He's in pain. And he's looking straight ahead the whole time during the body cam. He's not looking around. He doesn't know what's going on. He is stunned. He's out of it. And he is aroused when someone goes into his pocketbook. And then he reacts to that. Someone searching his pockets. He reacts to that. But he reacts to that as he's coming out of a phase where he's just stunned and hurt and in pain. And that doesn't equate to road rage.
All right. Relevance is a low threshold. And I do in the overall context, the arguably considered as road rage from both sides. Evidence showed that at the stoplight, both vehicles were stopped. Both vehicles accelerated at a rate far beyond what was safe for that particular area. And Mr. Vega did move over when that lane wasn't clear. So again, Mr. Little, I understand your argument, and that may have bearing later as far as relevance to letting this witness testify. And I think it's relevant to this. So, objection, perspective.
Thank you.
Ma'am, before all of that, I asked you, what was the nature of the analysis I asked you to perform?
Yes. So the nature was, you requested us to do a keyword search on road rage in our computer automated dispatch system from CAD. And you also asked us to search aggressive driving road rage from Titan statewide system.
Okay. I'd like you, let's start with the Titan analysis, actually. Aggressive driving road rage, can you go into more detail as to why that is a thing you could search?
That is a thing that I can search because that is a indicator that the state mandates within their system under driver actions. And when we can select that, is all based on what the officer or the investigator puts into the actual Titan traffic crash report.
So I want to make sure I understand you. A crash happens, a report is generated, and the state requires you to categorize that report as something. Is that correct? And so what you searched were the number of reports that were categorized as aggressive driving road rage. Okay. Was that statewide or limited to Hamilton County?
So we did a pool of 3 different distinct categories, and that is for statewide, Hamilton County, and the Chattanooga Police Department.
Okay. Going back to the CAD keyword search, you did what exactly?
For the CAD keyword search, we have to tap into the back end of the Hamilton County system because Chattanooga Police Department does not own that system. So we are allowed access into that software. And what we do is we write out a query, a keyword search query, to where we search for the incident of road rage. And then we also type in the parameters that you requested. For this one, it was specifically for all of 2022 to 2026 year to date.
Okay. And that year to date, I guess, endpoint, what date was that specifically?
That endpoint was June 30th,
Okay.
2026.
Now, you've said it, but you've obviously heard the term road rage before, right?
Yes, sir.
Would you agree with me that road rage in and of itself is not a specific crime in the state of Tennessee?
Yes, sir.
Okay. Would you agree that it is a behavior?
Yes, sir.
Is it a behavior that sometimes manifests itself in criminal acts?
Yes, sir.
Okay. Might it manifest itself as something that's not a crime, like flipping somebody the bird as an example?
Yes, sir.
Okay. Are you, and again, this is just by way of example, are you familiar with a case that was in the news last week where a juvenile was shot and paralyzed?
Yes, sir.
That case had an allegation of road rage.
Yes, sir.
And again, to be clear, that hasn't been litigated, but he was not charged with road rage, right?
Yes.
He was charged with attempted murder. Road rage is a crime that can manifest itself in any number of crimes. Could it end up as reckless driving?
Sustained at this point, in general, she's not qualified as an expert.
Sure. What are some of the types of offenses that road rage could manifest itself as?
It can manifest itself as vehicular homicide, reckless endangerment. It can result in specifically as vandalism. There's a wide range to it.
Sure. So any number of behaviors could show up. All right. Did you generate a report in this case?
Yes.
Was that a summary of the finding that you made in your research?
I've seen it. I've seen it. Justin advised me earlier in advance, and I've checked those for the same reasons. So I
Same
think,
reason for relevance?
yes.
Okay, same reason for perspective. You go ahead.
I'm sorry.
You go ahead.
No, Your Honor. Yes, please. Ma'am, I'm showing you this document. Is this your report?
Yes, sir.
Do you have a copy of that in that binder in front of you? Okay. If you don't mind, I'm going to work through this. You want your duplicate? I'd like to ask you, ma'am, the first question I have for you is related to the Titan data that we talked about. In 2024, statewide, how many crashes were noted as involving aggressive driving / road rage?
1,207.
Okay. And for the year of 2025, statewide?
1,103.
Okay. Statewide, was there a percentage change?
Yes.
What was that percentage change?
It was a decrease of 9%.
Okay. And year to date, how many have we seen?
579.
And to be clear, that is the June 30th of 2026 is your stop point? Okay. I want to go specific to Hamilton County now. In 2024, how many such crashes did Hamilton County as a whole see?
70.
Okay. In 2025,
101.
was there a percentage change between 24 and 25?
Yes.
What was that percentage?
44% increase.
Okay. How many have we seen year to date in Hamilton County?
48.
Specific to the jurisdiction of Chattanooga Police Department, how many road rage / aggressive driving crashes occurred in 2024?
55.
And in 2025,
81.
was there a percentage change between those numbers?
Yes.
What was that percentage change?
47% increase.
How many year to date have we seen in Chattanooga?
43.
Okay. Going to your keyword search for road rage in the CAD reports, what years did you search again?
I searched 2022 to 2026 year to date.
Okay. In 2022, how many actually, I want to back up. Did you take any steps to eliminate duplicates in this case?
Yes, sir.
Okay. So can you just briefly explain how a duplicate would occur? Yeah.
So duplicates occur within the CAD system based on multiple callers. There's oftentimes multiple callers that call in for one report or one incident. And the dispatchers typically merge those calls all together into the CAD system, but sometimes they don't always get merged together. It's just their process. Sometimes they miss some. So what I did in the process of this analysis is remove those duplicates that were still outstanding.
Okay. And I want to be clear here. When you're doing a keyword search through the CAD reports, all that means is that somebody called 911 and mentioned the words road rage. Is that correct? Okay. You did not do any sort of subjective analysis of the incident at all. It's just caller mentioned those words. Okay. In 2022, how many mentions in the Chattanooga area did we see for road rage?
266.
How many calls for service did we see in 2023?
309.
Okay. Was there a percentage change between those two numbers?
Yes.
What was that?
16% increase.
Okay. How about in 2024, how many calls for service regarding road rage did we see?
290.
Was there a percentage change between 23 to 24?
Yes.
What was that percentage change?
It was a 16% increase.
Okay. In 2024, there were 209. How many in 2025?
360.
Okay. Was there a percentage change between 24 to 25? What was the percent?
It was a 24% increase.
Okay. And so far in 2026, how many calls for service related to road rage have we seen?
101.
Okay.
Or 190.
Thank you, ma'am. Just give me just a moment. Pass the witness, Your Honor.
Ms. Anderson.
I have just a few questions about your testimony. So I just want to make sure I understand this in simplest terms. If I'm driving down the road and I think that someone is exhibiting road rage and I make that call, that gets on a CAD sheet, and then that is recorded in these statistics. Is that correct? Okay. Even though that has not been verified as a road rage by follow-up investigation? Is that correct? Okay, so it's just everybody in the street calling on the phone to the police department or 911 saying, hey, I'm seeing road rage. They just mentioned the word. Okay. I'm going to ask you this. Would you agree that the definition of road rage is uncontrolled anger triggered by another motorist, or a traffic condition expressed through aggressive, threatening, or violent behavior aimed at intimidating, harming others in the road? Okay. A common example would be yelling, cursing, or making rude hand gestures or other at other drivers. Brake checking, throwing objects, damaging property, brandishing a weapon.
Yeah.
Just one moment, Your Honor. Just one more question, Ms. Anderson. For example, in this case, where the prosecution report by the investigators makes a comment about the other driver, not Mr. Vega, and on that sheet they say road rage. Is that calculated anywhere in your reports?
Yes.
It is. Okay, so it's more than just the CAD sheet. Okay, so in this example, one of these statistics would be if investigator Cabot in this case put on the investigation report that Dr. McGinty exhibited road rage, that would be involved in these statistics? Yes. Thank you.
Just briefly, because I want to clear up a misunderstanding. Something only gets into Titan if there's a crash, correct? Okay, so if in this particular case there was a crash and there was a crash report generated and it was categorized as aggressive driving / road rage, that would end up in this data. Is that correct? Okay. You were asked about various behaviors that could constitute road rage. I want to ask you, in your experience, could cutting another driver off constitute road rage?
Yes.
Could rapidly accelerating constitute road rage? Thank you.
No, Your Honor.
Your Honor, state calls Mr. Ditt.
All official guidelines, as well as interpreting and translating, discharging all its solemn duties and obligations with interpretation and translation. You are Barbara, correct?
Yes, Your Honor.
Swear to
Raise your right hand. Solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
May I proceed, Your Honor? Thank you. Sir, could you state your name, please? And would you please, spell that?
Octavio.
Thank you. And if you don't mind, for the record, sir, Mr. Devia Pass, could you spell that as well?
Devia Paz, Devia Paz, Paz.
Thank you, sir. Mr. Devia, of course, you've testified previously at our jury trial.
No. Well, yeah, they did ask me some questions, but.
Yes, sir. Yes, sir. And that's what I'm talking about. Has anything changed about where you live or your employment since that time?
Everything.
Sure, and we'll cover that. When you were testifying previously, you were living in Florida. Is that still the same, sir?
Yes.
That's what I was asking. We need to go into a little more detail regarding what happened after you regained consciousness. And I'm going to
Okay,
be,
that's fine.
thank you, ma'am. And I'm going to be asking you questions about you and your family when you were struck on the morning of November 25th, 2023, and then what happened afterwards.
Okay.
You testified previously, sir, that you were unconscious for several days and you don't remember the crash. Is that correct?
That is correct.
Thank you. How many days were you unconscious?
3 days.
And then how many days after you regained consciousness did you learn about what happened to your wife and son?
About 3 days after that.
So about 6 days after the crash, you learned that Jonathan and Anna had been killed. Is that correct, sir?
Yes, my father and my family let me know. They couldn't let me know before because I had several surgeries and I was in sleep in between. I had surgery and I was asleep. I had surgeries. I just had a lot of surgery. That was the thing they could tell me. I had 24 surgeries.
I'm going to ask you some difficult questions, and the answers to some of these questions might seem obvious, but I need you to share those answers with the judge, okay?
That's fine.
What did you do after you learned you had lost Anna?
So I was just playing around with it in my mind, how, what, I couldn't really even do anything. I was like, at the time, like actually fighting for my life if I was gonna live or not.
You were having, it sounds like you were having difficulty processing it. Is that correct?
It was definitely, but it was a second. It was like just really heavy, even up to this moment. Fully processing.
And the same question for your baby Jonathan. What did you, is the answer the same? What did you do when you learned that you had lost Jonathan?
I was sad. I didn't know how or why. It was, I don't know how it happened. And I was even more sad because I couldn't bury him.
How has losing Jonathan and Anna affected you emotionally, sir?
Come on, I was dead. So a man who's lost everything loses the hope to live. It's not easy. It's like a wound that never can
Have you sought mental health treatment?
heal. Knows that I will. Yes, I have a psychiatrist.
Why? Why are you seeking mental health treatment, sir?
So I can't sleep. I forget things. Nothing's easy, and nothing's easy for me. And I have this like fury.
Has the emotional impact of the crash ended, or are you still suffering?
Sigue porque, pues, número uno, teníamos planes con nuestros hijos, niños sanos, y por eso. Y todo eso.
It continues. I mean, I had plans with my wife and son. He was a healthy, vigorous, lively kid, and it all ended in one moment.
You're not going to be able to see him grow up.
No, all the hopes I had just ended right there.
What effect does losing Anna and Jonathan have on you today, sir?
Ahorita sí, va a seguir.
It's just like an emptiness. It's an emptiness that nothing can fill. money, vacation. I don't wish that on anything.
Understand? I want to talk about you physically now. You testified that you've had 24 surgeries?
In one little physical care of this, yes.
How long were you in the hospital?
So where I had the first surgery, I was in for a month and 10 days. And then they transferred me to another hospital. I was in there about 2 months recovering. And then I went to another hospital in Florida and I was another month in that one.
Can you tell Judge Patterson about those surgeries? What had happened to you physically that required these surgeries?
Is that what they do? Let's try to look at my song. So I had fractured my hip, my legs, this area below, my left shoulder fractured. And I asked my doctor, is the pain ever going to go away? And he said, no, you're going to have to live with that.
That was going to be my next question. Was recovery painful?
Yes, of course. I had a setback. I had another surgery, and I had to have antibiotics for 2 months. And also my leg got burned because of the liquids from the car.
Are you still in pain today?
Yes, everything.
Can you describe the pain to the court?
Was it this? It's really strong. And I take pills for it, medicine for it, and sometimes they leave me kind of like drugged out.
Mr. Debbie, what physical limitations do you have today?
I can't lift heavy things. I can't run. I can't stand more than about 10 or 15 minutes. I can't work. It's been 3 years, but I haven't really gotten that much better.
Do you still need a cane to move around generally?
Yes.
Pero en general sí, estoy tratando de dejarle ver que estamos
Yes, I'm trying to get away from that and see if I can do without it
Good.
more if I'm liable.
Good. Now, to differentiate, you did not have these physical issues prior to the crash. These physical issues came from the crash. Is that correct?
Correct.
What activities did you enjoy before the crash?
I play soccer, I worked, I went camping with my family, I swam.
No more?
Yeah. Oh, and I would jog sometimes, but I would ride my bike. I went to the gym.
Are you able to enjoy any of those activities anymore?
No.
As a result of your injuries, I believe you testified that you were rendered sterile. Is that correct, sir?
Sí, estoy en
Yeah, I'm in treatment to see if that'll get better, but it
Okay.
also affected some of my internal organs.
And did you have to have additional surgeries for your internal organs as well?
Well, yeah, the doctor told me I'm not out of danger yet. I'm really not out of danger. What do you call it? I have some problem with the kidneys.
Yes, sir. Yes, sir. Can you tell Judge Patterson about your daily life now and how that's different from before the crash?
Well, I've had to start from zero. And I've had to let my mind just go blank. And sometimes I think it would have been better if I had just not.
We're a few months away from the 3-year anniversary, sir, of the crash. Do you anticipate that your life's going to ever be able to get back to normal?
No, it's not. No, there's something that's called like this, a spirit, and this is always going to be.
Mr. Devia, is there anything that we did not cover that you would like Judge Patterson to know about the crash, about what happened before or after, sir?
No, I think everything's been spoken. It's in the videos, it's in the testimony of the people.
Thank you, sir. Pass the witness, Your Honor.
No question, Your Honor.
Debbie, I've got a question for you. As you know, the sentencing hearing can result in incarceration or probation, perhaps with restitution, where the defendant might be in a court order to pay some money. Do you have a preference on whether or not, I'm not saying that your answer will cause this court to follow it just because of your answer, but I would like to know if you would prefer the defendant to have incarceration or probation where you would have to pay back some of the monetary losses that you probably suffered.
Pensar y hay que pagar los riesgos más para buscar el lujo. Y esto es algo que no es barato. Hoy en día son 40,000 personas que mueren así pues de cáncer. Y no está bien porque a veces no se aplica la reforma de hay fuerza en que la persona tome conciencia y sé que no es fácil para ellos estar en la posición para algunas personas pero ya siempre es una persona de leyes y luego todo
So my thought is someone needs to pay for their mistakes. There's a law. This has got to stop. There's been 40 million deaths by accidents, by car wrecks. This isn't good. So I think that people need to realize what they're doing. They need to apply the law. It's not easy, but sometimes there's jail. I mean, the law is the law is, and the state has to decide.
Any redirect that's one of
No, Your Honor.
any cross.
May I approach, Your Honor?
Yes.
Judge, there's a couple break meetings.
We've been in session some time. Let's take a 15-minute break. It's 10:40 on that clock. We're going to stay in session for other matters for the court, but be prepared to resume the sentencing hearing at 10:45. Thank you for that. Tuesday,
September the 8th, Your Honor?
or the 9th, whatever, better for you.
September the 8th would be better, Your Honor.
We'll come back on September 8th.
Yes, Your Honor, before we discuss an allocation, I'm sorry, Mr. Vega asked for some order. We have been made aware that the precedence investigation was not moved into evidence by the state. It does not appear that Mr. Creekmore is here, and that's not something that we had contemplated. But at this point, the defense would like to move the pre-sentence investigation into evidence. I understand that there is an argument that this is potential hearsay. It is clearly reliable hearsay. It was ordered by the court to be done. I know the court has reviewed it, as the court has referred to it a couple of times. I believe the court is under obligation to review it. I'll let the state say if they object or not before I go on.
I don't object to moving in the report itself. I do, however, reject all of the unauthenticated hearsay the defendant chose to supplement the report with. If the court looks at 45207, that lists out the contents of what a pre-sentence investigation is and what goes into it. And unless the court gives a specific order that the report is to contain something other than the fields in that statute, it's limited to those fields. So in English, all of the records that the defendant chose to send to probation, I would object to the court's consideration of them unless they have authenticated.
Typically, the way this works is the state puts it in on one side, puts it in. Sometimes there is an objection to hearsay statements given by a witness or a victim. And you take those up almost line by line. As I understand the state's objection, this does not include the actual report, which would have the risks and needs assessment as well.
Yeah, sure.
But the military-related records that you're objecting to, generally.
Yeah, sure.
I mean, the argument would be that those are in fact military records, and therefore reliable, and clearly something that Ms. Creekmore had considered when she created this report. She chose to attach those. As Mr. Forrest said, the defense supplemented these reports came to us attached to Ms. Creekmore's report. This was her supplement by things she deemed relevant, by things she decided to file in this case for the court.
All right, Councilor Brooks. So the PSI, he entered in its entirety, including the defendant's records, and it's not allowed to preclude you from making any argument about the liabilities. They will be attended.
Just, may I put you on? Thank you, Your Honor. We'd like to move that into evidence and have Mr. Vega's allocution.
Witness, you make an allocution, Judge, you want the lectern or the witness stand?
Make a witness stand, but he won't be sworn.
Okay.
Yes, sir.
State your name, your full name.
Randy Vega,
Mr. Vega, have I told you about your statutory right that you can make an allocution at your sentencing hearing?
yes, sir,
Would you like to do that now?
absolutely. Good morning, Your Honor. First, I would like to thank the Almighty God for the opportunity to speak on the tragic events and fatal crash killing Ms. Rodriguez, Jonathan, and severely injuring Octavio de Villapaz. Without further ado, I would like to send my most sincere condolences to Mr. Paz and his family. Señor Octavio de Villapaz, espero de que pueda encontrar compasión en su corazón para perdonarme. Thank you, Your Honor.
She'll be sworn, she's not a certified interpreter, but she'll be sworn as a regular witness. Mr. Little, if your client indicates that there's a different, if it was translated, just let me know.
Stand up, please. Solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, what is your name?
Randy Ramirez.
Ms. Ramirez, are you fluent in the Spanish language?
Yeah.
Have you been present today in the courtroom?
Yes,
Did you hear Mr. Randy Vega give his allocution a few minutes ago?
I did.
Did you hear him speak in Spanish?
Yes.
What did you could you please state in English what you understood him to say in Spanish?
What I remember him saying is that he asked for Mr. Vega Paz's compassion.
It was a rather long sentence. Did he say anything else?
He did. I just can't remember off the top of my head what he just said, but I do remember that he specifically asked for his compassion.
Thank you, Your Honor.
Anything beyond that?
Not this witness, Judge. If the court would like, we can put Mr. Vega up to say what he said in English.
Again, it's something for me to consider, I have to understand it.
I understand. We'll be happy to do that, Judge. So,
Thank you, Mr. Mayor. You can stand, it's allocuting, you can stand right there.
Okay.
You don't have to go to stand.
For the record, Judge.
So if you want me to consider what he said to Mr. Paz, I just need to understand what he said, so you can tell me what he said.
Yes, Your Honor, absolutely. I said that I hope that Mr. Paz finds compassion in his heart to be able to forgive me for the tragedy that has occurred.
Okay, thank you. Any other evidence from the defense?
No, Your Honor, we rest as far as it goes.
State offering in your rebuttal.
No, Your Honor.
Either side, wrong either.
Yes, Your Honor. We should prefer we speak from the lecture.
Makes it easier on both.
Sure. Where I would like to begin, Your Honor, is by addressing a pretty significant misstatement of law that has been made in the memorandums here. The basic premise of the defendant's suggested sentence is this: this court can adequately protect public safety simply by revoking his driver's license for a period of time, as the convictions for homicide by homicide by recklessness require. Okay, 3 to 10 years, I believe, is what the statute says. The court is told that will protect public safety at pages 8 and 9. It is stated that it would be sufficient punishment at 8 and 9. It will protect public safety at 13 and 14. The issue here is that if you give the defendant what he is asking for, that is simply not true. The defendant should have known that when he wrote it, because he quotes from the statute, which should have made this apparent. If this court decides that a judicial diversion is appropriate, and obviously we're here opposing that, this court needs to be aware of something. The Department of Safety only has the authority to suspend or revoke somebody's driver's license upon a, quote, final conviction. It is right there in 5510-501A. The department shall forthwith revoke the license of any operator upon receiving a record of the operator's conviction for any of the following offenses. And then it goes on to list stuff that suspends your driver's license. A diversion is not a final conviction. The plain language of TCA 40-35-313 tells that a person granted a diversion is not convicted of an offense because a judgment of guilt was never entered. It is a finding of guilt without the entry of judgment, which is where we currently stand today at sentencing. Quoting from State v. Dicus, a Supreme Court case 456 Southwest 3rd 918, at page 926, a defendant who has been granted judicial diversion and placed on a judicial diversion probationary period has not yet been sentenced. The court went on to conclude that the mandatory minimum sentences inherent to the Drug-Free School Zone Act are applicable only to those who have been sentenced. And since a person who is on judicial diversion has not yet been sentenced, those minimums, which in that case were longer than the 30 days of shock incarceration the court is permitted to impose under diversion, those did not preclude somebody from receiving a diversion. If the person were ultimately convicted by presumably violating their diversion and entering the judgment, only then would those minimum sentences be required to be imposed. What does that mean in English? The best that you can do if you decide to grant judicial diversion is order him as a condition of his probation not to drive. That's it. All of this talk about interstate compacts and how you can rest assured that Florida or New York or whomever will be officially notified that Randy Vega doesn't get to drive a car, that doesn't happen. None of that happens. What happens instead is, assuming the state even finds out that he's been driving, we have to then file a violation, come to court, and go through that process. It does not suspend his license. The court can draw its own conclusions as to how effective that process would be at protecting the public from this man. Where I went in my memorandum is down the line of what the court has to consider. Specifically, any sentence that the court imposes must be in line with the principles of sentencing. I cited two, well, it is the second factor, but it is stated in the alternative. There are two routes that I went on that second factor. The first is deterrence. Going down the Hooper factors, which control that, obviously this is conviction. He has been found beyond a reasonable doubt to have possessed a mental state of recklessness. State v. Hooper specifically says that reckless conduct or intentional or knowing conduct is more deterrable than other types of conduct. So that would weigh in favor of deterrence. I would also note this court tries plenty of cases every single year. Most of those cases are not live streamed. Most of those do not have every newspaper in the area in attendance. And I'm not even asking the court to look at facts outside the record here. It is in the record that this court called each of those reporters up to the bench and gave them instructions as far as what they could film and so on and so forth. This court is aware and can consider the extent of the media coverage in this case. I would note that during jury selection, we did jury questionnaires, which specifically had to go to how pervasive the media coverage was. Some of the jurors actually responded that not only had they viewed discussion of this on social media, but that they had actually participated in discussion. So I would submit to you that that is an indication that this case is of heightened public concern if people were actively discussing it. So that is Hooper's third factor. That's been met. The fourth factor on Hooper about a criminal enterprise, that's irrelevant here. This isn't some sort of gang shooting or anything like that. This is the defendant driving recklessly and killing people. It's just not a factor that's germane to this type of case. And finally, we get to factor 5. The defendant does not have a criminal history. He is before the court with a certificate of eligibility for judicial diversion. Hooper is a factor test. It's not a checklist of requirements. And when you balance those factors out, particularly factors 1, 2, and 3, those factors weigh in favor of a finding that this conduct may deter others. We are not held to the burden of showing that this case, a harsh sentence in this case, would deter others, only that it might. And what is the evidence that's in the record? Before the court, you have proof that crashes involving aggressive or reckless driving are actually on the increase in Hamilton County. While the statewide numbers were going down, we were going up, is what those trends show. You also had a general trend, particularly 24 to 25, of incidents where people called 911 and reported road rage. Why did I bring that up? As Mr. Little, mentioned in his cross-examination of Ms. Anderson, these are simply cases where somebody has called 911. There's no indication in her testimony that they were followed up with, resulted in an arrest, that something actually happened. And to answer that, I would direct the court to a case called State versus Hanning, which is 296 Southwest 3rd 44. That's a Tennessee Supreme Court case from 2009. What Hanning stands for is the proposition that even an unknown anonymous 911 call reporting reckless driving is inherently reliable. It departs from our general body of law that requires police corroboration of anonymous tips before seizing a suspect. In the Hanning court's words, when a tipster seeks to report the location of a reckless driver at the time the reckless driving is occurring or shortly thereafter, the tipster has a very brief amount of time to contact police, and the likelihood that the allegation is fabricated is proportionally diminished. Going further, the relatively limited amount of time available to the report available to report the location of a moving vehicle also diminishes the possibility that the tip merely constitutes an attempt by the tipster to employ law enforcement officials for the purpose of harassment. They go on to basically say it is improbable that people are going to make these up for the purpose of harassing people. In plain English, the Tennessee Supreme Court has held that when somebody calls 911 and complains about driving behavior that they're observing in front of them, that is to be considered inherently reliable. So much so that the police could actually pull somebody over in Hanning's case. And that holds true whether or not the caller identified themselves or not. So I would submit to you that it's actually a good idea for us to query those 911 calls indicating the number of incidences of road rage. Because as I asked the analyst, that does not require her subjective judgment. All this is a count of the number of people a year in Hamilton County that called 911 and say, hey, I'm observing or I am experiencing road rage. That's it. It is an objective number. So the case law does not require that we prove that a sentence will deter, only that it might. Mr. Little made a relevance argument as well, and so the reason I would submit to you that this is even relevant to this case is your own eyes. You saw the same video everybody else did. That is very aggressive driving by both Dr. McGinty and the defendant. You then have the defendant suddenly, rapidly cut his wheel, cut into Dr. McGinty's lane. I would submit to you that given all of the context surrounding it, it is a rational inference from the proof that these people were engaged in road rage. This is some sort of tit for tat thing by the defendant because he felt that he was cut off earlier. That is the inference that the proof would support. And so that's why this matters. I would submit that in this particular case, with the attention, with the data that the court has before you in the record, it is sufficient to support a finding of deterrence. But separate and apart from that is also the second prong of that, which is, and again, this is an alternative, is basically that this conduct is so egregious that the nature of the conduct alone can support a finding of incarceration. I discussed in my memorandum some of the stuff that courts have considered to find that specifically in vehicular homicide offenses. They're looking at the speed, the BAC, the force, severity of the wreck, severity of the injury, defendant's post-wreck conduct, and the fact that they endangered others. What you have here, obviously, number one, the defendant's conduct endangered others. There were, at the time he cuts the lane, I counted at least 10 people that were individually visible on that screen. Surely there were other people on the road that day. His speeds, unfortunately, they were both traveling nearly twice the speed limit. And it's not just the fact that they were going twice the speed limit, but where they were doing it. This is a very pedestrian heavy area. This is a place that folks go on a Saturday afternoon to shop or recreate or do whatever it is they're going to do. That, to me, I would submit makes it more egregious. It's not just the fact that they were speeding so much, it's where they were doing it that really gets us there. The force and severity of the wreck, you had testimony in the record that the building appeared like it was almost going to collapse. You had the supporting pillars on the building were visibly canted inboard. I would submit to you that they're supposed to be straight to hold up that overhang. Awful lot of rubble. And then you look again at not just the force and severity of the wreck, but the severity of the injury here to get to that. And what do you have here? You have Miss Rodriguez, who flies up, hits the ceiling. According to Dr. Cogswell, her head is no longer connected to its spinal cord. It's moving freely. You have an 11-month-old child whose brain is laying there on the sidewalk. That's a lot. It's rough. The jury, frankly, didn't get to see a lot of that because it would have been probably more prejudicial than probative. So I would submit to you that the facts surrounding this are, again, more egregious than others. What I would compare it to is that case Gavin Tyler Sheets that I quoted. That is a case where Judge Greenholtz, actually writing for the CCA, conducted a de novo review of the court's analysis because the court failed to properly find under the electroplating factors. He felt that he had enough information to go ahead and make his findings in the record. I would look at the facts of that case, though, not just Judge Greenholtz's findings. That was a case involving a 20-year-old kid who was driving like a moron on a back road with his friend, the passenger. They go off-roadway. He wraps his car around the tree and he kills his best friend. That is tragic. I'm not here to say that that's not tragic. This is next level. This is you can commit this sort of offense without going to the depths or going to the extremes that unfortunately this conduct got us to. So I would submit to you that those are two areas that the court could find to justify a sentence of incarceration. Moving on to the electroplating factors, I would submit that we have some information in the pre-sentence investigation, but we don't have a lot of information. What I mean by that is this. We know that the defendant was in the United States Army from 2003 to 2012, summer of 12. We know that he reports that he had a skydiving job as a videographer in 2019. He apparently sustained some sort of work injury, which kept him out of work. And then the next thing we know is the defendant's own statements that in the PSI that he had just completed training with Covenant in 2023 to become a CDL driver. I would submit to you that there is case law, specifically State versus King, 432 Southwest 3rd, 316 at page 329. The Tennessee Supreme Court says that when there is nothing remarkable about somebody's employment history, that factor is to be neutral. You have a lot of blanks on that resume, for lack of a better term. It could have been fleshed out better, but it was not. So I would submit to you at best that is a neutral factor. Also in the pre-sentence investigation is the defendant's physical and mental health. The PSI mentions that the defendant was diagnosed with a TBI and PTSD. I believe his medical records also indicated the same thing at trial. He tells us in his memorandum that the defendant has been, I guess, doing the responsible thing by seeking treatment for those diagnoses through the VA. He also notes in his memorandum that it is a, quote, later traumatic brain injury. I think that's important to point out because that seems to suggest that the TBI came after the service, or else why would you distinguish there? But I want to take a step back for a moment. On the one hand, you have the defendant as somebody who has spent 2 years in Iraq. He is morally injured by what he experienced overseas, and that is supposedly, according to the defendant's version of events, at least a contributing factor to this tragedy. On the other hand, he's being responsible, he is managing his conditions, and he apparently does not have an alcohol issue at all, according to his own statements. He supposedly drinks 4 to 5 beers a month, according to his statements in the PSI. So I guess my question is which is it? Either the PTSD has something to do with the behavior, or it doesn't. He says he doesn't have a drinking problem. He says he's managing his conditions, and apparently there's really nothing to worry about with him. And oh, by the way, that image of him being a jerk on scene and saying what he said, that was the only time that PTSD even matters in this case. So I would submit to you that what you actually see in the pre-sentence investigation is somebody who has a history of aggressive behavior. The strong R assessment at the back goes into some detail as to what his statements were about that. He is described as aggressive. He is described as impulsive. None of those things are positives for him under electroplating. They're not. I would submit to you this. If the court considers that his mental health is good, that would be a positive. The Court of Criminal Appeals has specifically held that a report of PTSD, which largely stemmed from a defendant's participation in the offense, has neutral bearing. Also in State versus Eugene Smith, the CCA found that a PTSD diagnosis for which the defendant had not previously sought treatment was also considered neutral under electroplating. And then you have also in Gavin Tyler Sheets that that person was supposedly diagnosed with depression. Judge Greenholtz felt that weighed neutrally. It didn't weigh for or against. But I would submit to you this. If the court is to decide that the defendant's diagnoses had something to do with his behavior on that day, that would weigh against it. So either his health is good, his health is okay, in which case it's neutral. But if it's driving the behavior, whether it's his impulsiveness, his aggressiveness, that's going to cut against him. Moving on with the electroplating factors, amenability to correction is another factor. One of the things that is cited in that Eugene Smith case is that was a person who had entered a best interest plea and did not accept any responsibility for his actions, is what they found. Here, what you have from the stand, according to the defendant, he is thankful to his ability to speak on the tragic events. He offers his condolences to Mr. Vega. What you did not hear, he says that he hopes that Mr. Vega would forgive him. He's apologizing for the tragedy, for the situation. What you do not hear is, I did this. I am sorry for what I did. I'm sorry for the situation you experienced. Well, okay. That's not an acceptance of responsibility here today. I think everybody in the room is sorry for Mr. Vega. And again, the other electroplating factors are deterrence. I've already spoken on that at length, so unless the court has specific questions, I'm not going to repeat that part. And then the seriousness of the case. Going back to Gavin Tyler Sheets, Judge Greenholtz held that a judicial diversion and probation in a vehicular homicide case would depreciate the seriousness of the offense. And that was a situation where a young man was driving on some country back roads and killed his passenger. Again, this is a lot more than that. The other situation is very tragic. But again, as I said earlier, this is several orders of magnitude more severe. As far as the enhancement factors, there's quite a bit of nuance to what the state wrote in there that I do want to highlight, because the defendant made some blanket statements that certain factors that I cited do not apply. Factor 1, that is the multiple victims factor. If the court chooses to apply this factor, you cannot apply it simply because the case had multiple named victims in the indictment. That fact alone does not get you to that, because that is double dipping, for lack of a better term. What you can do, however, is find that there were other victims in the case that were not named in the indictment. And I identified 2 that would qualify under our statutes and our case law. Dr. McGinty's vehicle suffered damage. He was, as the defense repeatedly notes, he was a participant in the situation, so I don't expect that to be particularly compelling. But I think the damage to the Walnut Bridge shop is significantly more. That's an awful lot of damage. Their merchandise is covered in brain matter. There's an awful lot of rubble on the ground. They're not even in business anymore. Factor 3, the victim was particularly vulnerable. The defendant seems to be arguing that everybody on the roadway was just as vulnerable, but that's not what the case law requires. The case law does not require that a defendant select a victim because of a vulnerability, that would obviously carry a lot of weight if they did. It simply requires that the victim be less able to respond to than others. You have an infant child in a harness, he's got to go wherever his mom goes. Even if he saw it coming, he wouldn't be able to leave. That's why he is more vulnerable than others. The factor 6, injuries inflicted, are particularly great. You cannot apply that to enhance homicide counts because death is the ultimate injury. You cannot apply it to a reckless aggravated assault simply because the victim sustained serious bodily injury. Again, that is inherent in the offense. However, what our courts have held is that extensive psychological injuries would qualify, even in cases where serious bodily injury is an element. Specifically, State v. Messick, that is 2015 Westlaw 212-867-1. That is a Court of Criminal Appeals case from 2015 that was a vehicular assault case, which held that so long as there was specific and objective evidence demonstrating that the victim's mental injury is more serious or more severe than that which would normally result from an offense, you can apply that factor. That's page 9 of the opinion. Again, that was a vehicular assault by intoxication, so similar but slightly different here. You have a guy who lost his entire family. He testified he is experiencing mental anguish even today. I think the quote that I wrote down from him was, "A man who has lost everything loses the hope to live." He talks about the plans that he had for his kid when he was growing up. He doesn't get to do that anymore. That is not inherent in every vehicular assault case. This is several orders of magnitude worse than your run-of-the-mill case. Finally, factor 10, the no hesitation factor. The defendant asserts that you cannot apply that as a homicide. That is simply untrue. The Williamson case that I quoted to was a vehicular homicide by intoxication. That was the Supreme Court conducting yet another de novo review of the trial court's actions. They asserted that the trial court should have applied this factor because the roadway was busier than usual. They said should have applied it. So the trial court didn't, they said you should. So I'm not a detective, but I would call that a clue. Those factors are the same for probation and diversion. They're just named slightly different. So again, I'm not going to be redundant there, but I would submit to you that the balance of these factors weigh against both a sentence of probation and a sentence of diversion in this particular case. That is the state's position. As far as consecutive sentencing goes, factor 10, the multiple victims factor, you can sentence something to consecutive sentencing when there's multiple victims, if that is, court finds that's in the interest of justice. That hasn't really been fleshed out in our case law yet because that's a fairly new factor. I think 2022 is when that came into effect. Why is this in the interest of justice? Again, I would submit to you the severity here is great. It is reasonably related to what we saw here today. You only need to find one of those, but I also talked about the dangerous offender factor. The defendant cites to a case Braden, and I want to distinguish from that case a little bit. In Braden, you had no evidence that the defendant was intoxicated at the time of the crash. The jury found beyond a reasonable doubt that the defendant was intoxicated in this particular case. Whether or not they found him guilty of homicide by intoxication is a different matter, but he has been convicted of DUI. In Braden, you had a defendant that was constantly employed, had no real history. Here, the only verified work history we have is the Army from ending in 2012. He got his CDL in 2023, and then he had the skydiving job for an unknown period of time. We don't know for how long or how secure his employment has been, but I would submit to you that you don't necessarily have somebody who has a very long and stable and secure history of employment, at least based on what is in the PSI. If there's more information out there, so be it. He says he does have a plan. When he gets out, he wants to do some sort of charitable business helping homeless veterans, and that's great. That's commendable, but that's a difference than Gavin Tyler Sheets, which that guy actually had somebody testify, when he gets out, I have a job right here for him. Continuing on with Braden, there was no evidence in that case the defendant had a history of drug or alcohol abuse. His PSI says both things. His self-report is that he drinks 4 to 5 beers a month. He also, in his strong R, suggests that he's been drinking heavily at points in his life. He is somebody who self-reports that he is under a no-contact order for his own child. I don't know the circumstances of it. What I would submit to you is that anybody who went to law school knows that it's actually a pretty high burden to keep you from your own kids. So something's going on there that I think the court can consider. The defendant argues against that. Argues that the dangerous offender factor should not apply. The multiple victims factor, neither of those are in the interest of justice. Why are these factors in the interest of justice? Or why is applying this factor reasonably related to the severity of the conduct? Let's talk about it. There's a toddler's brain on the sidewalk. Mom is dead next to him with her head flopping about like a fish. Dad has got lifelong debilitating injuries and the mental anguish that he testified to today from the podium. The stores collapse. Folks who saw this probably all traumatized. And then as the defendant pointed out at trial, the traffic pattern had to change due to all this. The defendant is sitting, and meanwhile, here's what you have. You have the defendant sitting on the sidewalk, displaying not the first hint of remorse or concern for those that he injured or killed. This is not a situation where you have some high schoolers out celebrating after graduation. Maybe the driver does something stupid, wraps his car around a tree and kills his friend. That is a tragedy that could well be charged in a similar manner as the offenses the defendant was convicted of. But this offense went well above and beyond the baseline for this sort of thing. Where I want to leave the court is this conflation by the defendant of accidental with recklessness. The two are not the same thing. This is not a case where the defendant was merging onto the interstate, didn't check his blind spot, and maybe caused a collision on the interstate, which led to a death. That is an example of an accident. The defendant was found beyond a reasonable doubt to have consciously disregarded a substantial and unjustifiable risk. Consciously disregarded. That is not the same thing as unintentional. The fact that he didn't mean to kill Anna and Jonathan is completely irrelevant. If he meant to, we'd be here talking about a murder. It's not. This is a vehicular homicide by some incredibly reckless conduct, and I submit to you that it warrants a very harsh sentence, and that is why the state is asking for the 18 years of incarceration. Yes, please.
On the child custody matter, this is something that he could have voluntarily relinquished his parental rights, have no contact.
All it says is a court ordered no contact. That's all the report says.
Well, I don't want to give additional weight to something that's
Sure.
too speculative, where it could have been something where it was taken away from him.
It is in the context of him being his wages being garnished for child support. It's where the statement comes. I don't know anything beyond that. Sure.
Because there's a speculation. But I didn't want to give you a chance to respond for something else. But the more, I guess, significant factors in this case, to me, is the fact that this defendant has no significant criminal history. I think that's significant because for most of the road rage cases that this court has seen, that's the norm. It's people who qualify for work. It's those who are business people. I mean, I'm not, for the record, I'm not using these to determine, what this defendant's sentence is, but I can say that the last several road rage sentencings and that I've witnessed deal with someone who, or people who were almost pillars in the community. So there's something about, this is something in this particular defendant has served our country. Whether we get into the details of his records from PSI, to me, he served 2012, honorably discharged. So he seems to fit the norm of a road rage incident where the defendant is charged, someone's killed because of this, but there's no significant history. Is that something that, I'm curious what the state's.
I want to make sure I understand your question. Are you asking me, is it normal for folks without a history to engage in?
The state's perspective on a defendant who has basically no criminal history, has done something as damaging as this. And this seems to be the norm of road rage. Does the state have a position or a broader perspective? I know you're asking for the maximum 18-year sentence. It's, I don't say baffling, it's certainly incongruous. A lot of the other folks that I know you see where the charge was something and there's a death related to it. It seems like this is just one more of the many road rage cases where someone with no criminal history, in this case, a decorated veteran, but ends up, because of his actions as judged by a jury and this court sitting his 13th jury, caused the death of a little boy and his mom, permanently injured the dad. So you got, on one hand, you got this egregious, extremely extensive amount of damage to society, to Paz's family, to personally. On one hand, you got, this is something that typically seems to be people with no criminal record, like Mr. Vega. They have any thoughts or perspectives on? So
I have not personally prosecuted a case like this, in meaning the nature, a road rage related vehicle homicide. I've prosecuted plenty of intoxication related ones, and the overwhelming majority of the defendants in that had no criminal history. But that, again, that's my frame of reference, which isn't quite as germane here. I think what sets this out is, again, the significance of what happened in this case. You have, arguably as a result of this case, you have that change in the traffic pattern, as the defendant argued at trial. The fact that the victim in this particular case, or the victims, excuse me, if you were to make the argument that it's Dr. McGinty and the defendant going at it, for better or worse, had Dr. McGinty been the person who got injured, at the end of the day, he was a voluntary participant in these actions. These are people who are from Florida that are just minding their own business on a corner waiting for the crosswalk, and they are the ones who get hurt. They are that for lack of a better term, pure innocent victim. They didn't engage in conduct which would result in their death. How little led up to this. You have Dr. McGinty. He is driving from Red Bank. He comes in. He's coming into what becomes Frazier Avenue. He has to move out of his lane to avoid the defendant, and then as soon as he can, he gets right back in that left lane. I don't know, it's not on camera, but I would argue he probably cut him off, whether he meant to or not. Okay. It would be reasonable for Mr. Vega to perceive himself as being cut off. That's it, one interaction. There was no evidence of any back and forth between these two, and of course it's a fairly short distance between those lights. You have, that happens at the manufacturer's light, you then go to the market, and then you're at Woodland, which is the final light. So you're talking about a couple blocks tops, but there's just no real back and forth. I mean, you have McGinty's testimony that he didn't even realize anything was wrong until that last light. And then at the drop of the hat, we go from, for lack of a term, 0 to 100 in this. I mean, not that they reach speeds of 100 miles an hour. That's just a metaphor. Over something so minor. This wasn't something that built up to it. And,
Isn't that the norm for road rage, where people with no criminal record, educated people, war veterans, have nothing that we can, in hindsight, is worth that. There's nothing that's worth it, right?
Well, yeah, I would agree. I mean, there's no good reason to engage in it. I guess the point that I was making is I have seen other non-homicide offenses, and there was one tried in Judge Dunn court as an example where they were going down Rossville Boulevard, or no, not Ross. It was in East Ridge somewhere. I forget the exact road, but there was a long interaction between the two before the gun came out. And fortunately, nobody was hurt in that particular case. I can think of, again, just cases I've seen come across my desk where there is that back and forth between the two. Here, maybe it just didn't have the opportunity to get to it. But what baffles me is the degree of the reaction to this light. I mean, I might expect a honk and a middle finger. I can't say that I haven't done that myself in the past, but how extreme the reaction went. The fact remains is that people without history do commit, one of the hard parts about being a DUI prosecutor is that you're dealing with so many people who, but for this, they've got a job driving a FedEx truck, or they've got, a server's license or whatever that this would jeopardize, and that, but for this, this arguably, relatively minor misdemeanor has such a dramatic consequence. And it's one of those crimes that normal, upstanding citizens, unfortunately, sometimes commit, whether they set out to do it that night or not. Unfortunately, that's the nature of the beast with vehicular crime sometimes. What I would also point out in this particular case is separate and apart from this event are the defendant's history, according to the strong arm, of that aggressive and impulsive behavior. Whether or not it ended up in a criminal conviction, you still have him reporting that. And that is, to me, significant. You've got to realize a problem before you can work on it. But if you're reporting, hey, I've engaged in, this aggressive, impulsive, angry behavior in the past that has led to, as the report says, quote, antisocial behaviors, that to me is a clue. That's a warning sign. Even if you don't have that or even if you don't have that criminal history to build you up there. I would note that Gavin Tyler Sheets case that I've quoted from a few times. Again, not only was that person a 20-year-old, but that was a diversion-eligible 20-year-old. And Judge Greenholz held not only a sentence of incarceration, but a maxed-out sentence of incarceration. It's not, unfortunately, sometimes with vehicle crimes, you take them as you get them. So,
Thank you.
yes, Ron.
Mr. Vega.
Your Honor, questions the court just asked of Mr. Boyers. I find interesting and intriguing. Actually, probably pondered those questions myself. My own personal experience in driving is that I tend to be annoyed by another driver normally when I'm running late myself. It's just my own experience. Sometimes if I have plenty of time, it's not that big of a deal. If I'm driving along the road and I tend to be late, or I got to be somewhere at a certain time, someone drives slow in the left lane, or they zigzag out of my way, or even if I catch a red light, I think it annoys me for whatever reason. So I don't know what the answers are to your questions there, but I do find them interesting, and I ponder them myself.
I don't know if there is an answer.
I don't know if there is, but I would like to start by saying, Judge, what I'm going to do before I get moving, I'm going to address some of the arguments that were made in the state's memorandum regarding enhancement factors, maybe a little bit on the probation issue, and Ms. Haddock is going to handle most of the other issues that the court may inquire about in the memorandum that she filed for the defendant, if we may. First of all, since I started off talking about the question about the road rage, and I think I alluded to this earlier, I don't think the defense does not believe or see the facts in this case that elevate to where road rage is in the presence of or in the mind or anyway on Mr. Vega's part. And here's why I say that. Because of the facts. I'm not making any inferences. I'm not making any presumptions. I'm just talking about the facts. So I just like to, and I did this earlier a little bit, but I just like to remind the court of the facts, because that is what the court is supposed to look at. Obviously, it's the facts that were introduced to trial. It's one of the areas the court has to look at. And so there is a video that shows Mr. Vega driving on a side street that was captured by a local video. We have cameras everywhere, and a camera. And so he approaches Spears Road, and he's slowly. I might add, he's driving slowly. He approaches that intersection, and there was some issue about him running this red light. I mean, this red light. I mean, this stop sign. But the road was at an angle, and there were cars parallel parked all the way down. So in order to get a good view, you've got to roll out to look. The reason I bring this up is because he did it very slowly, very carefully, and he made that left turn. And then there's another camera that shows him driving by, and where he headed toward Cherokee Boulevard at the time. And there are two buildings on both sides, multiple levels, that could obstruct some vision unless you kind of poke out a little bit. So now I'm going to leave that scene. I'm going to go to Red Bank, where Mr. McGinty testified that he left the Ace Hardware store and was driving up the road that goes to Springer, the tunnel that goes from Red Bank onto Cherokee Boulevard. And he encounters a white truck that pulls out in front of him. He has to slow down for that purpose. Mr. McGinty testified that he was on his way to work, and at the scene, he said he had to be at work at 3 o'clock. The accident was after 3 o'clock. It was around 3:12 or 3:15. So when he gets to the tunnel and on the Cherokee Boulevard, there's another vehicle that is almost stopped in the left lane. And he testified that he passed that car going 52 miles an hour. It's a 35-mile-an-hour zone. And so this is what's leading up to Mr. McGinty running into or encountering Mr. Vega. Mr. Vega pulls out, I'm going back, he pulls out of Spears Road onto Cherokee Boulevard to make a left. The accusation is that because of that, Mr. McGinty's got to move, suddenly got to move over to the right lane. Well, he just testified he passed a car with 52 miles an hour. So, it's possible that Mr. Vega misjudged the speed of Mr. McGinty coming down Cherokee Boulevard. Those are facts, Judge. Those are facts. Now, so they stop. The next first red light or traffic light is Manufacturers Road. We don't see Mr. Vega anymore. We don't see any more of his vehicle from the dash cam until we get to Woodline. So there is no encounter testified to or caught on video between the two victims. I believe between the two drivers. The next one is North Market Street. Again, we're viewing this from the dash cam in the Nissan truck that Dr. McGinty is driving. It gets to North Market Street. In North Market Street, but the stoplight, yes, the stop. It's a red light. Yes, the stop. Some cars drive by on the right, and they make a turn on the Market Street Bridge going across the bridge. We do not see Mr. Vega. He's not pulled up beside him. Nothing is going on that we can see that Mr. Vega is driving, doing anything. The next thing we see is the light turned green, and they drive to Woodlawn. Now, there was a video that was put into evidence called the Walgreens video that actually our investigation team is the one that found that, and we, in reciprocal discovery, provided to the state, and they chose to put it on. There is an argument in the memorandum that you can see Mr. Vega in his van changing lanes and moving over to the right lane so he can get beside the defendant. Well, there's no proof of that. You've watched the Walgreens video. You don't know. You can't see him changing lanes, but at some point he did change lanes. But that doesn't mean anything. It doesn't mean anything at all. Interesting to note, after you pass North Market, there was a sign, an orange sign on the right, diamond-shaped sign that says the right lane is closing ahead. Now, Mr. Vega is now in that right lane. He sees that, assuming, well, he passes that sign in the dash cam. In the Walgreens video and on the dash cam. You can see that. Now, they stop at Woodlawn. Dr. McGinty is in the left lane. Mr. Vega is in the right lane. And there was video from the storefront there showing that stop. And as I said earlier, Investigator Molnak said there was nothing that occurred there. Nothing on the video they could see. Testimony we have from Dr. Vega Dr. McGinty is that he looked over and he saw Mr. Vega looking at him. I think he used the term stare, looking at him. No other reaction. Mr. Vega did not open his mouth. He did not throw him a bird. He did not wave his hands up and down. He did not deploy a weapon. Nothing other than he just looked at it. Now, Mr. McGinty is looking at it too, and he testified earlier that he passed the van when he had passed that car for 2 miles an hour, and he passed the van when he pulled out in front of him. He did take note. Dr. McGinty did that. They had an out of town tag, and the van was dirty. He noted all this for whatever reason. He noted it, and so when they get to Woodlawn, and the traffic light turns to green, Mr. Vega's vehicle accelerates, and so does Dr. McGinty's. But Dr. McGinty tells us what is going on in his mind. He says that for whatever reason, when he looked over, some dread came over him. Now, here's where I will make an inference. I think it's an overreaction by Dr. McGinty. And so Dr. McGinty says that he saw the van pull ahead of him, and he said, I did not want him to get in front of me, so I hit the gas. That's his testimony. Now, that you can see that in the video. Well, you see how they leave in the dash cam video. So now I want to go to the Masonic video. So the Masonic video doesn't show when they leave the Woodlawn traffic light. It doesn't show that because they're not at the Masonic video yet. That doesn't occur until they pass the last building, until the area is open. And Investigator Molnax and Investigator Warren both testified that they did not know where the point of impact was. Both of them testified that. They did not know where the point of impact was. Mr. Patrick testified that the point of impact was right before the intersection. You can see it on the Masonic Lodge video. You can see where it's, and I would describe it like it's a pit maneuver. It's kind of what it looks like. I'm not saying it is, but that's what it looks like. And then that's when the van went out of control and ran into the building, and then we have this tragic ending. It's tragic. I mean, it's just, I would not want to be in the shoes of Mr. Potts. It's a tragic ending. And Mr. Vega is paying for that now, and will pay for it later. So now that I've said all that and talked about the facts of the case, I don't see anywhere in that scenario where road rage is applied to Mr. Vega. I just don't see it. And I submit to the court that it's not there. Now I can step over and talk about Dr. McGinty and talk about several examples why I think road rage is there, because of his trip from Red Bank, the encounters he had with other vehicles, the fact that he was late, and his overreaction when he looked over and saw Mr. Vega looking at him. I think that road rage applies there, and investigator Cabot put in his prosecution report that road rage was attributed to Dr. McGinty. And then what Dr. McGinty said was, and after this, I'm going to move on to the other factors, Judge. Don't want him to get in front of me. I was speeding too fast for conditions. I decided to accelerate to keep him from taking the lane. His car left ahead in front of me. I hit the gas, accelerated. I was acting to the caravan's acceleration. That is the way my brain is wired. My speed was absolutely not safe. When he was asked by investigator Warren said, Dr. McGinty, if I just can't help but think, but if you weren't there, this would not have happened. And Dr. McGinty's reply was, that's what's eating at me. Now, those are all the facts that the court saw about this tragedy. Yes.
The fact that both your client and Dr. McGinty were going very fast, well beyond the speed limit for both doing.
Just I'm sorry. I thought I said that he accelerated from the traffic.
Accelerated.
He accelerated the 50.
Far beyond the speed limit.
He did.
And it was clearly anyone who lives here longer than a year knows that, that particular area is usually saturated with shopping, with its locals, with its tourists. The city's done a lot to try to get folks there, and it's worked. So those are facts that, also need to be included, I think. And, respectfully, I do think that this was a road rage related situation at both parts. It doesn't take two people to, consequences like this, but I think the facts in this case are such that looking at Mr. Vega staring at Dr. McGinty, right? McGinty was staring right back at him. But for whatever reason, the client was looking for the testimony very intently at Dr. McGinty. After that, for whatever reason, it's almost like it was understood by both parties that Mr. Vega was going to try to get over, and he didn't want him to get over. Mr. Vega was going to get over anyway. It wasn't like an immediate lane change. It was accelerated. If I recall the testimony correctly, I think both of them were over 50 miles an hour at the time when Mr. Vega tried to cut over. And neither one of them wanted the tragedy that happened after that day. I guarantee you, either Mr. Vega or Dr. McGinty would have wanted that. However, you drive a couple thousand pounds of steel, especially in a heavily populated area that fast, and it's almost like shooting a gun in public. I didn't intend for him to get hit, but if you make that decision, the consequences can be devastating. It seems that Mr. Vega, while he did not intend that, as the state points out, he intended to do it to be a different charge. It was very reckless. Convicted of homicide by reckless conduct. I think that road rage is part of it. So, if there's anything else I'm missing on that, you can.
Judge, yes, I did not mean to imply that he was not speaking. Yes, he was. The jury found Mr. Vega guilty of reckless driving. I'm sorry, reckless homicide, because he was speeding and he made an improper lane change. There's no refuting that. But I don't think that establishes the fact that road rage existed in Mr. Vega's head. Respectfully, I don't think that does. Yeah. Yes. Right.
We moved on to the point.
Yes.
I do disagree with the defense position. I do think that road rage was a big part of this. But I didn't want you to move on without me letting you know
Judge, I also understand that the state has the complete discretion on how they make their charges. I understand that, and I respect that. A lot of times, I encourage it. Obviously, not what I do for a living. In this case, I'm just puzzled by it, and I think that's about all I can say about that. That the puzzle of the fact that Dr. McGinty's criminal responsibility that I assert in this case he was not charged. Based on the statements he made to police, based on the statements he made to police and the evidence. Judge, I want to comment on the scene that happened after the accident and I did talk about this just a little bit earlier, but when Mr. Vega was, we don't see him when he was removed from the vehicle, not on video, but when the body cams of the police officers and first responders show up, he is sitting on the sidewalk. His back is to the gift shop, and he's looking straight ahead. Never does he hardly look anywhere else, especially he never looks back behind him. It's not clear he knows what's going on because he's been in an accident with 50 miles an hour, hit a building, airbags deployed, and he is hurt. He's in pain. He spent about 4 days in the hospital, so it's hard when they're have just encountered that kind of situation. He doesn't say he's sorry on scene, but he's stunned. He's in pain. Maybe he doesn't. It's not clear he knows what's going on around him. He doesn't know that about the child, unfortunately, or Miss Anna. Doesn't know. He doesn't know. There's no proof that he knows that at that point. And I can't help but point out the fact that someone who has been in combat for as many times as he has and has endured IED explosions, and he's stunned and he wakes up like that something is not triggered. It's a possibility. There may not be any evidence of that, but it's a possibility. Judge, I think the court has already addressed this issue of the child. We don't know about the child restraining order. We don't know what's going on there. This could have been something that. And I won't belabor the point. I think the court knows, and they're going to much weight to it. We don't know if something was filed and it didn't respond. We just don't know. Again, there's no prior record of convictions, Judge. The state talks about the incredibly risky behavior at the slightest perceived provocation. But again, I would just argue that I just don't see provocation on the part of Mr. Vega in this case. Judge, in the state's argument in the memorandum having to do with alternative sentencing, the circumstances of the offense is particularly committed. In this case, were more egregious than is contemplated simply by the elements of the offense. They go on, we can talk about the Boggs case, some comparison to this case. There's also a case cited talking about incarcerating the defendant is particularly suited to provide an effective deterrence to others likely to commit similar offenses. All of the cases have to do with an individual driving on his own, either intoxicated or driving recklessly, or there was one case about an arson case. The defendant was acting on his own solely. There was no other person where criminal responsibility could be attached as well. That's the difference in those cases. And it's kind of distinguishable, Judge. I don't think the court can just erase from their mind or erase from what they saw at this court about the potential criminal responsibility on the actions of Mr. Vega. I'm sorry, Dr. McGinty. And none of these cases have that kind of factor in them. And I just want to point that out. There's also a comment in the, it's page 8. These are not numbered. I numbered them myself, but in the memorandum, state's memorandum, talking about no attempt to put on brake lights. Well, in the video, the brake lights did come on. Whether they were completely applied all the way, there appeared to be an attempt that Mr. Vega did apply his brakes, or tried to apply his brakes. And the state acknowledges in their on page 9 that I've numbered memorandum, even Dr. McGinty, who can fairly argue bears some moral responsibility for his role in the wreck. I would say it's criminal responsibility as a judge. It's tough on how they balance this issue of him not being charged, but he could have been. Sorry, I've been slow, Judge, to make sure I don't miss anything. I don't want to repeat myself, and I'll do that. Interesting fact that the court looks at is this publicity, the media. Judge, the last 4 trials I've tried have all been streamed. They've all been streamed. It's just the way it is these days. They've all been streamed. The court did not require us to do a questionnaire. The defense asked for a questionnaire because we felt this was a better way than the court's suggestion, with due respect, and I think the court allowed us to do that. So it wasn't required. We did it, and seven prospective jurors were dismissed for cause. 7. Most of those jurors may have remembered something, an issue, maybe a name. A couple others, maybe a little more than that. A lot of news about there's also a lot of news about why Dr. McGinty wasn't charged. That was a lot of the news that played out. As a matter of fact, at post-trial, juror number 45 made a statement to Channel 9 News saying that Mr. Vega was guilty of reckless driving, but or being reckless is not a huge part of his fault. And they found him guilty of reckless conduct. But Mr. McGinty had a huge role, and they felt and questioned why he wasn't charged. That was the statement she made in the press. So it's just more than just his case based on his actions. There was also media about for months about the changing of the road and how the city planners went in and changed the road, and the area mainly was traffic. And then it becomes like a small Gatlinburg, if you will, where a lot of people are walking on the streets and there's no changes to the road. That was part of the media too. Circumstances of the offense warrant denial of both probation and judicial diversions. The argument by the state, and quoting State v. Williams, that many people were visibly endangered by the defendant's conduct, and the fatal outcome of his high-speed lane change is entirely foreseeable. Well, the argument the defense is that he sped up above the speed limit and moved to the left lane. I don't think there's evidence of him, even though Investigator Warren said he looked like he cut him off. I don't think there's evidence. I think it's just evidence he's merging, not realizing that recklessly, not realizing that Dr. McGinty is got a different perspective. And I don't think that was foreseeable. There's also some out in the memorandum of the state. We talk about the blood alcohol content, suggesting that he drank 8 to 9 drinks. Judge, and they extrapolate that from a 0.015% that Dr. Carswell testified to, who did not obviously take the blood of Mr. Vega. There are a lot of factors that involve how the alcohol increases the blood alcohol content, having to do with weight, having to do with what's in your stomach, having to do with how your body metabolizes. It could be as much as a 0.04%. Judge, the court take judicial notice of this. It could have been 3. It could have been 3 drinks. It could have been 3.5 drinks. There's no evidence that he had 8 to 9 drinks prior to this accident. And more importantly, the jury found that intoxication was not the cause of this accident, Judge. And an important part about a point I want to make is that in the counts 1 and 2, he was charged with vehicle homicide by intoxication. The jury found him not guilty of that, and they went on and found him guilty of reckless homicide by reckless conduct. So ruling out intoxication as cause of the accident. They went on and found him guilty of vehicular homicide by reckless conduct for counts 3 and 4. Of course, the court already knows, and we all agree that they merge. Interesting that count 5, he was charged with guilty of vehicular assault. And in order to find the defendant guilty of vehicular assault, they has to find intoxication. They found him not guilty of that. And not only that, the next lesser included offense was guilty of driving under the influence, and they found him not guilty of that. And then they found him guilty of assault. So it's clear that, and then separately, they found him guilty in counts 8 and 9. But that's just telling you how the jury felt that intoxication was, they ruled, they found him not guilty of intoxication caused this accident. Judge, as far as enhancement factors by the state, the offense involved more than one victim. Obviously, that can't be applied to the homicide counts or the assault counts because they are inherent in crime. So they're essential elements of the case, and they cannot be used. So the enhancement factors cannot be used in those particular cases. Judge, there is an argument that enhancement factor that involves more than one victim cannot be used in the offenses of the counts that merged. Yes. Okay. There is an argument, Judge, by the state that an additional victim in the case. Well, first of all, they allege that, or they argue that Dr. McGinty is a victim in this case. I strongly oppose that argument, Judge, based on his statements at trial, his statements to police. The damage to his vehicle was on the front bumper of the truck, the Nissan truck. I think that's just a stretch. I don't see that. Now, they do talk about the building that was hit, the Walnut Street gift shop, the damage there. Judge, if there's any, of course, these are advisory under the court's perspective, but it would, if the court were to find that, it would only be to the reckless endangerment. It would not, because those are not named individuals in that count. The victim of the offense was particularly vulnerable because of the age or physical or mental disability. Judge, this is a tough one to argue. It's because the sensitivity of it. But this is kind of, there was a case that talks about anybody who's in a direct line of a bullet being fired. They're not vulnerable. They're just, everybody's vulnerable, but it's not particularly that reason. At the time of this accident, Miss the mother of the child was holding her son in her arms. Was not on a harness. I mean, whether the harness was on there or not, the child was in her arms. That's clear from the video. And I don't this doesn't apply. It doesn't matter who was standing there at that one point. It was going to happen. The accident, the injuries were going to happen. The deaths were going to happen. There's an arson case, State v. Lewis. In that case, there was that's cited in their memorandum. That was a case where someone had set an apartment building on fire. There were infants that were in bed, and people had to go rescue them. And that's the kind of scenario that this would apply to. And State v. Lewis again. Yes.
Second after 2 seconds to instinctively go one way or the other. She could have helped her get higher, from one side or the other. I'm not faulting her for her decision to go on. Makes a distinction. Mother could die. The mother had, it wasn't especially vulnerable because everyone, an adult, half on kind of vehicle has the same level of vulnerability. It seems like a child wouldn't even have that 2 second ability to decide he can't get his mother's arm. It does seem like important to something up again. Bring it up and let you respond.
Thank you. Judge, I've watched the video on this particular point. It's hard to watch. It's tragic. But there was less than a second. It's less than a second. It just was less than a second. So the victim's age or physical condition, this is Lewis in 44 Southwest 3rd, 501. The victim's age or physical condition might make the victim vulnerable in a general case. That particular vulnerability, however, may play no part in the crime. The vulnerability that is wholly irrelevant to the crime is not appropriate for the offense. And so holding advanced age of a victim irrelevant when weight, lifter, football player, or any other person, male or female, who possessed adequate strength to resist a crime against this person would have been killed by the defendant's gunshot. So that's what I was alluding to earlier, gunshot. I just don't think that there was the fact that the child, his vulnerability, his age, would have made a difference. It's making a difference, and I don't think that factor should be applied. The personal injuries inflicted upon the amount of damage to property sustained or taken from the victim was particularly great. That does not apply. The name in counts, homicide counts, the assault counts just don't apply because the individuals are named. They just doesn't apply. And there's some discussion about physical injuries, Judge. Psychological injuries, I believe that State Barnett, from my read, doesn't matter. Doesn't provide an enhancement factor in this case. The defendant had no hesitation about committing a crime when the risk to human life was high. Judge, I think the only place I can see, the only place that would go to is the reckless endangerment offense. And the last one, during the commission of the felony, the actions of the defendant resulted in the death of a serious bodily injury. There's no evidence to support this factor. No authority cited. And if it was, it would only apply to the reckless endangerment. Yes, that's in the memorandum. It would only apply, Judge, if the court found it under advisory guidelines. It would apply to reckless endangerment. I don't think there was an intended victim at all. I just think there were victims as a result of his reckless conduct. I would argue there's no intention at all.
Say, correct. This is support actually Mr. McGinty.
Judge, and I would argue based on how I opened up earlier is that there's just no proof of that. There's no proof that he intended to cut Dr. McGinty off. He tried to change lanes. And if you watch the Masonic video, when it comes into play, the van is almost in that lane already, and there's no contact at that point. And I laid those pictures one by one, frame by frame. And Dr. McGinty said, I asked him, were you hitting the gas in this one? Boom. Yes. Were you hitting the gas in this one? Boom. Yes. Were you hitting the gas in this one? But went on 6 times. And before the impact, it didn't slow down. So because of that, what I would argue is criminal responsibility. Mr. Vega had no intentions of he was Dr. McGinty was not an intended victim. It's just the proof doesn't bear that out. I'll argue, Judge. Judge, I think that's all I have to address in as far as enhancement factors. Mr. Hedrick would be happy to answer any questions you have for us. Yes, Mr. Hedrick.
Yes, I'm being tagged in. I know we're kind of bouncing all over the place here, but I'd like to go back and just touch based on a few of the highlights from our sentencing memorandum, because his social and employment history is a factor for the court to consider in both probating the sentence or alternative sentencing, as well as the diversion statute. As the court has been made aware and has commented on several times, we do know that Mr. Vega was a combat veteran, having served in the Army from 2003 to 2012, was honorably discharged, has suffered significant physical issues as a result of that combat service, as well as some mental battles. Why is this significant? The state mentioned, that the employment history, if it's not outstanding, should just be neutral. I do think that being a combat veteran, having chosen to serve his country, is something outstanding. And the court seems to understand that, as I've noted in some of the comments that you've made during this hearing. I'd also just like to point out that military service also shows discipline, dedication, acts of service, leadership, and also being able to follow rules, take orders. These are also things that the court can consider when deciding if probation is appropriate. This particular line of employment would show that he may be better at these things or better served for this kind of a sentence than perhaps some other employment or things of that nature. While on the issue of employment, the state had brought up the fact that there are perhaps holes in the pre-sentence investigation concerning where specifically he was employed from 2012 until the date of the accident in 2023. It does mention some commercial driving. We don't know where, how much, based on what was set forth in the PSI. We do know that there was some schooling, that he was just shy of an associate's degree, so we know that he had attended some college during that time as well. I would just like to point out that if the state wanted to use those holes against him or have the court consider that, they had the ability to bring in Ms. Creekmore and chose not to do that. She did not indicate any issues with any significant gaps of employment in her PSI. And I think if that was something that the court needed to consider, that was certainly something she could have pointed out. You have before you a 46-year-old man who's reached middle age without any criminal history whatsoever. While the state wants to point out that his strong R assessment does talk about some perhaps aggressive behaviors, again, if they wanted to flesh that out, to have this court consider that kind of thing, they could have brought Ms. Creekmore in to talk specifics about that. What we know is that even considering any of those things that he mentioned to her, she still categorized him as low, low risk. And that's what the court needs to consider. None of that was enough to elevate that up at all. If Mr. Vega had a history of this kind of reckless driving or these kinds of aggressive behaviors, they certainly would be before this court. On the contrary, the PSI indicates that he was a commercial driver, which would indicate that he has a fairly good driving record and that this was something that he actually, careful driving, something he took seriously. He was here being educated for the purpose of commercial driving. You do not have a negative history of driving patterns in front of you. Mr. Vega, according to the PSI, we know that Mr. Vega has a sister who is present in the courtroom today, Your Honor, along with her husband. She was also present throughout the trial, having traveled from New York. She offers him her full support if and when he is released, in helping him get back on his feet and making sure that he can adhere to any conditions that this court puts upon him. He has a mother who also resides in New York who is living. She's in her mid-80s. She probably doesn't have a significant amount of time left, but could certainly use his help at home, and he would certainly appreciate the opportunity to visit with her. So there is family support. There is a place for him to go. There is a way for him to get back on his feet and be a productive member of society. It was mentioned in our memorandum, I'd like to mention again here, he does not intend to be a citizen of Hamilton County or Tennessee, which I think is something the court can keep in mind. One of the consequences of this incident for Mr. Vega is that he will no longer be able to drive commercially, obviously. And we can get into this license suspension issue in a moment. That's not something that's going to be available to him with these convictions on his record. I'm not sure that's available to him, even if the court grants him diversion. So that is a penalty that he will serve. That's something I just like the court to bear in mind. He will have to start over in whatever he's going to do to make a living. And as we did indicate in our memorandum, he does have a plan, something he would like to do to complete his education and work for something that can help homeless veterans going forward. If the court doesn't have any additional questions concerning social and employment history, I can move on from there. I think we've been over a lot of that this morning.
Yeah, just again, road rage is something that's it's baffling to use one of the state's terms in the sense that people like Mr. Vega, his late 40s, his mid-40s at the time it's happened. Don't know much about his employment history, but I know a lot apparently about his service to our country, and made it through 30s, in his 40s. Then this particular incident ends up with an entire family basically destroyed. You know, I feel for Mr. Pons, since and he said that the person who has something taken away loses everything, loses the will to live. So it's the same person. Mr. Vega is the person you're describing, his military history, is the same person on that particular day got into what I think is a road rage incident, destroyed a family. So I guess that somewhat pertains to his history. Well, if you have any thoughts you could share on that or want to share.
When the court first brought that up to the state, my first thought was, you know, in the sense of DUI, that's another area where we see a lot of otherwise upstanding citizens that do make that error of judgment ended up being convicted of DUI, as opposed to a lot of our other crimes where, you know, your average person's not involved in that. And in the sense of DUI, right, the legislature's come down pretty hard on those. DUI is not diversion eligible, as we all know. That Mr. Vega's DUI will say on his record for life and will be used to enhance any future alcohol-related incidents going forward on his record. It seems the legislature has addressed that already. They have yet, I hear the court's point that we've got this person with no prior record, and obviously you're supposed to consider that in determining what kind of sentence. The statute says that he's presumed a prime candidate for alternative sentencing because no prior record. What I think I'm hearing the court say is, yeah, but this issue, this road rage, as the court has indicated you believe this has ended in this terrible tragedy, and why aren't we doing something about that? And how does that not weigh more heavily in here? The legislature hasn't addressed that yet. Again, they have in DUI, they have in certain other kinds of crimes, but thus far that has not become a crime in and of itself. It was not anything that was put before the jury. It's not listed anywhere in any kind of enhancement factors. And we do have a pretty significant list of things that the court is to consider and look at and talk about. And as of yet, the legislature hasn't determined that that should be one of them. So I certainly hear what you're saying. I guess all I can say on behalf of the defendant is that that's not in our list of things to talk about today.
Well, in terms of incarceration, one of the factors deals with effective deterrence.
Sure.
The state did put on proof that road rage instances are increasing. You know, and that is one of the elements to get into incarceration. If there have been similar crimes in this area, in the state, and proof has been put on about that, this seems to fit squarely into yet another road rage incident in Tennessee, where it turns deadly. So I think that while there's no statutory factor at all on road rage per se, it certainly is raised in this sentencing context as effective deterrence under 4035-1-3. I don't know if you want to address the proof that the state put on about the increasing nature of road rage, or I think that since the legislature has remained silent on it, that it hasn't risen to a level of something that should be factored heavily. But I do think it's something we talked about. It's narrative to talk about.
Well, I can clean this up a little bit. We can begin to talk about the alternative sentencing then, and working backwards. Obviously, the first thing that we are to look at is whether confinement is necessary to protect the public. As I did state in the memorandum, I do believe that the license suspension can and will cover that part, and I can get back to that in a minute too. The next issue, of course, is deterrence. Your Honor, Mr. Vega spent 33 months in prison. Mr. Vega lost his freedom on the date of this accident. Mr. Vega will have to live with this for the rest of his life, just like, I'm not going to say just like the victims, because it's nowhere near what the victim has to deal with, but he too will carry the very heavy burden of what happened, what he saw, what he experienced, and what he had a hand in. And that is deterrent. All these people that watched this trial, since the state brought up the fact that it was live streamed, that is deterrent. Having seen what they've gone through, and having seen the horrific nature of the accident itself, the trial in and of itself, and this conviction in and of itself is a deterrent. He's not been without penalty thus far, even if the court was to give him the benefit of diversion today. I do believe that the deterrent nature that the deterrent side of sentencing has already been applied here. Anything else we could deter, a greater prison sentence is not going to change how the public looks at this point. Back to the confinement issue and the protection of the public. Again, I'm going to try to modify some of what I would have said normally, because the court has made it very clear you do believe this to be a road rage incident, but the actual crime was recklessness and reckless driving. So again, what we have to protect the public from is dangerous, reckless driving, road rage. If he's not driving, none of that is no longer, then the public's no longer at risk of that. Because we're talking about the sentencing, the state brought up a very interesting point, and the truth is I don't know the answer to this, but the vehicular The reckless vehicle, I say this wrong all the time. Vehicular homicide by reckless conduct does carry this 3 to 10 year sentence. The statute that talks about the Department of Motor Vehicles applying that suspension is a separate statute. I think that they act independently. I think that this court still can and is actually statutorily obligated to suspend his license for 3 to 10 years. What the Department of Motor Vehicles does with that, first of all, in my experience with them, is anyone's best guess. But there's nothing that says that your 3 to 10 year suspension does not go down simply because the diversion is granted. That the sentence would expire anyway. Any prison sentence would expire anyway prior to the license suspension expiring. I don't see how that keeps the Department of Motor Vehicles from actually entering that suspension. The state mentioned the compact. As you know, Tennessee is not a member of the compact. We act like we do. We act like we are. As far as I know, and for everything I've seen, we do send suspensions on to home states. In any event, even if that didn't happen, any out-of-state driver still does have to clear the Tennessee suspension in order to be able to have a license renewed in another state. Please.
Is the state asking for suspension of license in this case?
Absolutely.
Just making sure I understood the statement.
Yeah, so that's my argument as to confinement being necessary to protect the public. First is the license suspension does take care of that. He has been incarcerated for 33 months. Additionally, there's no pattern of conduct here that suggests a need to protect the public from future crimes. If this was a single act of reckless driving and or road rage, since the court has categorized it that way, that does not inherently demand stacked sentences in order to reflect the severity. These crimes are felonies. They do carry significant periods of probation and or incarceration should the court choose to do that. The punishment is severe enough already, I would argue. I think confinement, from what I'm reading, from what I'm understanding from our sentencing laws, is supposed to be the last line of defense. You don't have any history of probation violations, no history of an inability to follow rules. Again, on the contrary, you have someone who's a combat veteran who was trained to follow orders. I don't think that the state has made an argument that confinement is necessary to protect the public. And again, I don't believe that there's any failure of a less restrictive measure as discussed, Your Honor. Probation and conditions of probation can do the job of deterrence and also protecting the public and future safety. And as the state mentioned, the fact that the factors for diversion are very similar to the probation factors. I'll just run through this quickly as a lot of this has been addressed. Rehabilitation, from the PSI, it would appear that there are no alcohol or drug issues specifically to be dealt with. Certainly, if the court was concerned, you could order no drinking as a condition of probation. There is a DUI here. I do think it's reasonably related. In any event, I don't think that there's rehabilitation to be had. Certainly, as far as his driving goes, perhaps, since that was what happened here, a reckless driving act. But again, the court can handle that with this significant license suspension. The nature of the circumstances of the offense, again, this is tough because this was a reckless driving act and not an intentional crime. That has been belabored. The court has indicated that yes, even though it wasn't intentional or we'd be talking about murder, that this one act did cause significant harm. But the only thing I could ask the court to consider in that is that Mr. Vega was not the only party. While Mr. Vega did come over, perhaps before it was safe to do so, and was speeding, Dr. McGinty again did testify that he sped up to keep him from coming over. But for that, it is quite possible this accident doesn't take place. I think that still needs to be considered, that there was an additional factor here that caused this accident outside of just Mr. Vega's having done a reckless driving act. And I'll say this again, or I'll get back to it, but that's also one of the mitigating factors we would ask the court to consider. So I'll get right back to that. The other factor for diversion and or probation is criminal history. I think we all agree there's no significant criminal history here whatsoever, which should certainly weigh in his favor at this age, at 46. And again, under this statute, Mr. Vega is presumed to be a favorable candidate for alternative sentencing. Finally, not finally, because we have to deal with consecutive versus concurrent, but the mitigating factor we would ask the court to consider is factor 11, that says the defendant, although guilty of the crime, committed the offense under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the criminal conduct. Kind of massaging this a little bit, but I do think that the fact that Dr. McGinty sped up to keep him from coming over does come into play here. Again, the act is, if the crime was the reckless act of illegal lane change while speeding, that in and of itself would not have necessarily caused this accident, but for this car coming at him to keep him from being able to complete his lane change. He had no way of knowing that that's what was happening behind him. I don't think at the time Mr. Vega went to get over that he believed that Dr. McGinty was going to speed up so he couldn't get over. So, but for that intervening factor, the accident may not have occurred. And I think it's important to note that he didn't make that lane change with the understanding that a car was going to come speeding up behind him and they were going to collide. It clearly wasn't criminal intent to commit homicide while he did commit a driving act. I do think that factor could apply, and it is a fair place for the court to consider the fact that there was a second actor within what happened within the accident itself.
Isn't it like two people deciding to get into a gunfight and they miss each other, someone else in the building? I've heard a lot, about how maybe Dr. McGinty's participation, but for that participation, it happened. I mean, this is something where it seems like two grown adults, one was driving under influence, got into a road race. So I'm not putting as much weight on the fact that Dr. McGinty participated in the context of reducing any culpability on Mr. Vega. It's almost like two guys rob a bank, one of them gets away, and one of them gets caught. Just because the one got away doesn't mean it reduces the culpability for the one who got caught.
I understand that completely. The only thing I would say to that is when two people are in a gunfight, and the court made this point earlier, yes, bullets are flying. When we're shooting a gun and a bullet's flying, it can be presumed that someone could be in the line of fire. This was an illegal lane change. I mean,
2,000-pound steel vehicle.
And Dr. McGinty's was bigger.
Sure.
I understand.
Does it take the 2,000-pound vehicle out of your client's control on Frazier Avenue, at least 20 miles an hour speed when the place of population is? And again, I've said this before, just want to make sure that in the context of what we're talking about this moment, Dr. McGinty's contribution to this doesn't seem like it to the court that it should reduce to the Vegas fault. But again, I wanted to bring up while you're on that topic to see if you had any, to give you a chance to respond.
I understand. And I think that I tend to agree with you to an extent, but for that one mitigating factor where it does say these are unusual circumstances. We don't always have crimes where we're dealing with it, but for someone else having been involved and colliding, it wouldn't have happened. So I think that is the one area that the court could consider that, should it choose to do so. We are arguing and asking that the court sentence Mr. Vega to each of these counts concurrently. That is the presumption under the law in order for this sentences to be consecutive. My understanding is the state would have to convince the court that there's a specific reason for that. As we are aware, the court has separate counts for each victim. The law does allow for concurrent sentencing based on his no prior history whatsoever, the fact that no one intended for multiple victims to be harmed or any victims to be harmed. I do believe that concurrent sentencing is appropriate. Does the court have any questions as to sentencing?
No, I think we discussed what I'm interested in hearing about and covered very thoroughly. I followed Dr. McGinty's contribution, Mr. Vega's history, and the second.
Okay. Yeah, I just say again that I understand that death is death, but this was reckless and not intentional, and I think that the law allows for that, and it does get sentenced on a different level than had this been an intentional crime. And I do believe that the sentences allotted by statute for these felony charges cover the severity of the consequences of the crimes. Yes.
The only, I'll be brief, just because of what the court has questioned the defendant in some response, but I did want to bring up a few things that were brought up during the enhancement factors. Specifically, Mr. Little talked about State versus Lewis when the state cited to the multiple victims factor, and he talks about how that case involved in arson, many people in their beds, many people endangered, so on and so forth. He skipped right over the next case that I cited, which was State versus Kelly, which was just somebody's parked car that got a stray bullet. Okay. The point that I'm making here is that it doesn't have to be much for somebody to be considered a victim under the statute. And if that storefront looking like that, the way that it does, frankly, looks like a bomb went off in front of it, I don't know what victimization is there. With respect to enhancement factor, excuse me for just a moment. With respect to the personal injuries inflicted factor, again, Arnett, the case that I cited in my brief, says that it can enhance. The other case that I cited in my initial one was a vehicular assault case, where once again, those psychological injuries could enhance. This blanket statement of that factor can never apply in an assault or a homicide case is not correct. And those are two cases which have found that that is the case. Same thing for the no hesitation one. Again, the Williamson case that I cited to is a vehicular homicide by intoxication. That was the only count in that offense. So again, those can be used to enhance. This argument that confinement is supposed to be the last line of defense, the last resort to the court, maybe if we were here in juvenile court, yes, because that's in effect how juvenile court is you just progress, you progress, you progress until finally state's custody is the end point. Our sentencing act, on the other hand, only says that sentences of confinement should be based upon the principles of sentencing, which are found in 4035-103. Doesn't say anything about when you get to that. I think what is most significant to me, though, as the court is aware, the defendant bears the burden of establishing his suitability for both probation and diversion. And to me, it's shocking how little the defendant was actually mentioned just now. About every third sentence was Dr. McGinty this, Dr. McGinty that. It's almost like there's no agency whatsoever being assigned to the defendant. The court has repeatedly said something to the effect of it takes two to tango here with regard to these two, but just to belabor that point a little bit, if he really felt like he needed to get over, he had a brake pedal. He didn't use it. It wasn't that he may not have grazed it. The testimony was that from Joe Moore was that he made no meaningful attempt to brake. But if he really was just confused by the traffic pattern or whatever, all he had to do was slow down. He had plenty of room in front of him. That's it from the state.
Judge, in response to the Lewis case, I didn't skip over anything on purpose. I was answering the court's question. I think the court knows what I was doing. So I read a piece of it. I didn't read the entire case before the court. I think it was necessary. The judge, yes, we, as the court knows, defense, we cannot go without talking about Dr. McGinty's actions. I think the court understands that. The fact that we have brought it out during trial, the fact that we brought it out today, I don't think we are analyzing at all about his criminal responsibility, his moral responsibility in this case. And I think we have to point out differences in some of the cases the state decided, and why this court should look at this case a little differently because of that, because of Dr. McGinty's actions in this case. And respectfully, well, I think I'll stop there, Judge. Thank you.
There are a number of analyses that need to be done, so just taking one by one. Regarding proof of birth today, we heard from Mrs. Anderson, who testified about her crime intelligence numbers, that road rage, the nutshell is road rage is increasing in the area. That these are numbers that her information agency gathers from the city and Hamilton County and the state as a whole. The court does find that the road rage seems very clear to me is involved in some aspect of why it is happening. It is increasing in our area. We heard from Xavier County Fast today. Very compelling testimony as it was during the trial. I remember from the trial, we talked about how spent the day on the North Shore, decided to go to the aquarium. Last thing he remembered was hitting the button across the street. Wakes up 3 days later in the hospital, was told that his son and wife are deceased. As devastating as that by itself is, injuries they testified to the trial and today still continue to afflict them in lack of. I think he might have been the most articulate witness where we needed an interpreter ever had as far as the descriptions that he gave about what it was like to be there on that day. And to, he said today, a man who has lost everything, lives the will to live. General Polito was sure to ask him questions why he's seeing a psychiatrist, because he was wanting to work for that, which does indicate that he does want to somehow get through this one, cope with it, that he does have something to live for. I hope that continues to be the case. The fact that he is sterile now is something that this court hasn't heard before in terms of how many things can you take from someone. This is one more I hadn't heard before. Mr. Paz is dealing with that too, and hopefully that treatment will be successful in some regard. And the court places great weight on his testimony, as well as the state's witness about the road rage increasing. Defense exhibit about the pre-sentence investigation is also taking a state objection about the military records being included. So the court did review everything in PSI about the defendant's history, lack of history, his meritorious in service to our country. In the, as I recall, at one point, his PTSD diagnosis was increased to 100% disability. And so that was certainly something the court viewed as well as a strong arm analysis that showed that he was a low risk in most regards, while he did have some aggressive tendencies that put him at moderate risk. Okay. This brings us to be considering factors for sentencing. The evidence in the received trial and sentencing hearing, we talked about PSI, which we just talked about. principles of sentencing, which we'll get to in just a moment, as far as incarceration versus probation, the nature and characteristics of the criminal conduct involved, what was everyone in the courtroom learned a lot about the nature and characteristics of criminal conduct involved in this case throughout the course of this case. Mitigating enhancement factors, which we'll get into, we'll discuss. I didn't call any AOC information for some practice in Tennessee. I see Jerome Moyle actually snuck some in and wanted to send some memorandums last time, but I haven't seen it for this particular case. Statement the defendant allocated on behalf today, which I certainly appreciated his words, seemed sincere. The victim, again, the validated physical needs assessment conducted by the department, also part of the case. So let's start at incarceration versus probation analysis. 35.103. The one factor that has two potential ways to arrive at incarceration: deal with appreciating the seriousness. Anything less than incarceration would appreciate the seriousness of the crime. And the second aspect of that is provide an effective deterrence. If the court does find that that factor has been met by proof, make that again. Any type of road rage is like shooting a gun in public. Road rage with two people is like two people having a shootout and not really considering the consequence for everyone around them, including each other. Road rage is something where, again, as the state said, it baffles me to some degree, but it's a consistent aspect of our society for some reason. You don't know what the person in the car next to you is going through. You don't know if they just buried a child. You don't know if they just got a cancer diagnosis. You don't know if it's a distracted teen. You don't know if it's an elderly person. It may be someone who's a jerk. You don't know that. But this was a case where the road rage that was part of this is absolutely something that I think needs to be deterred in this community. I think the state has proven that the factors are present for that. The factors, these are increasingly present in the community jurisdiction and the state as a whole based on numbers. Factor 2, that the offense crime was resulting in reckless conduct. Substantial publicity has been attached to this case for good reason. I think Chattanooga has, when it comes to tourism, amazing spots, just fun little parts of our town. Chattanooga has a number of those, and this was one of them, the North Shore. And the media has a job and a role in making sure that things that hit at the heart of this community are covered. And this is one that qualifies as such. So factor 3 is clearly satisfied as well. Factor 4, this is not an enterprise, so that does not apply. And factor 5, the defendant has not previously engaged in the same type of conduct, so that does not apply. But I do think the other factors are present. We should be given enough weight where effective deterrence, anyone else decides to basically pull out a pistol and start shooting, which is the same thing as, in this court's opinion, as operating a vehicle on roadways that everyone has to use, especially in a touristic area like this. I do think that the fact is clearly satisfied in both of those appreciate and effective deterrence. So the sentences of all of these for incarceration. As far as setting the length of the sentences, there were numerous enhancements and other mitigating factors that were argued. Technically, Dr. McGinty could be considered a victim. defendant crossed over and recklessly drove his car into Dr. McGinty's truck. Say that makes a good point about how Dr. McGinty's truck was smaller, was bigger. The defendant's vehicle was probably smaller, it was needed. I think the state, they created on their part, didn't think about the score as an actual victim, but I believe that he qualified as a victim that was not charged, not an indictment for vandalism or destruction to the store. I do think that the factors could apply. As far as weight to get into it, it's not as great as some of the others. I think factor 4 does apply in Jonathan's case. I think that he was particularly vulnerable. I think it made a slight distinction, which you little maybe pointed out how it didn't matter who was in the path of that vehicle. Same thing was going to happen. I do think that factor, at the very least, I think there was at least a chance some person might have seen what that might have 1 second. The kid in the arms might have tossed the kid to the side. And that was something that Jonathan didn't have the capability to do, so I do think that applies to Jonathan's case. And for factor 6, as far as Octavio's damages, psychological injuries absolutely fit, go along with the recurring nature, potentially permanent sterility. I do think that really applies. Factor 6. Factor 10 about no hesitation, risk of life is high. Again, this is well known. This is a place where lots of people in this area congregate regularly. And the risk that life was high. Speeding, going 50 miles an hour, that risks life in that particular area. You get to a road rage incident, try to cut off Dr. McGinty, who might have deserved it. Might deserved having his car damaged in some way. You both would have been charged perhaps. Your charge might have been less than that, Mr. Vega. But Kai's family did not deserve what I think were very foreseeable consequences of having that type of altercation in that particular area. I do think that could applies to closure. As far as injury to someone other than the intended victim, again, the store might have qualified, Dr. McGinty might have qualified. I think that's probably a little technical. If it does apply, of course, not giving much weight to that role. As far as the mitigation that was raised, factor 11, the defendant, although guilty of the crime, committed the offense under such unusual circumstances, for the like of that sustained intent, criminal conduct. I think that's every road rage. That's every reckless act where instead of like letting the person have the lane, you escalate. Guess what? Sometimes they escalate. So as far as unusual circumstances, in one person's history, I don't think Dr. McGinty's ever going to get to a road rage incident again. I hope Mr. Vega does it when he gets out. As far as unusual circumstances, as the state pointed out in its brief, these are everyday things. People are going to cut the law. Like I said before, you don't know why. It could be actually intending to aggravate you, or it could be for a host of number of reasons. It could be because they got some really bad news. There's a terrible day. They're looking for it. You just don't know. So those are things that we all deal with. Everyone who drives deals with. I don't think they're so unusual that mitigating factor 11 should. The catch-all that was mentioned, I do think Mr. Vega will serve this country in a way that many other people can't have. His service does not excuse his conduct at all, but under the law, it is a factor that the court can consider. The court does give significant weight to his past service our country and his complete lack of any type of chargeable offense that I can tell, other than traffic violations of Florida. So we'll come back to that. So that was the last mitigating factor. So I'm going to set the sentence lengths based on the enhanced mitigation factor, and we'll talk about the second concurrent. Parties agree counts 1 and 3 merge. The sentence for count 1 will be 2 years to serve. Sentence for count 1 will be 4 years to serve. Sentence for count 3, which merges with it, will be should write the basis on count 1. It's count 1. All right, this is the honest sentence. The mother was killed. Count 1 will be 4 years to serve. Count 3 be enhanced upwards from the 3 to 6, be enhanced upward to a 5-year sentence to serve. Put on. Counts 2 and 4 with Jonathan. Count 2 will be 4 years to serve. Count 4, as it will be enhanced upward with the additional fact that I find that he was particularly vulnerable, but that be enhanced to a maximum of 6 years to serve. Count 4, those two will merge. Counts 5 and 6 deal with Octavio. Guilty of a misdemeanor will be less than 29 days to serve. Reckless and aggravated assault as a D felony, period from 2 to 4 years, will be enhanced upward from 2 years to 3 years to serve based on his extensive psychological injuries as well. Count 7, reckless endangerment. That's an E felony. That's for the public at large to put at risk. The sentence was set at 2 years for that one. Then counts 8 and 9, they merge as well, be 11 months, 29 days to serve. Minimum $465 fine. I know this is moved in some ways, but since they're mentioned statute, I have to put it down. We go to school and lost the license. But the license in this counts 3 and 4, this license be suspended for 5 years. Those two counts as well. All right, consecutive confirmed. I think that clearly factor 10 is present that 2 or more offenses were committed with more than one victim. That factor is clearly present. And I do think that in the interest of justice, each victim needs a separate sentence in this particular case. The court does also find that the risk of life was high. Since the court talked about earlier about this particular area, the speeds and the ongoing altercation that escalated to the devastating consequence that we had today. So let merged count of 1 counts of 1 and 3 run first. The merged counts of 2 and 4 takes your sentence run second. The merged counts of 5 and 6 run consecutive. The most recent ones I mentioned, a total of 5 years, followed by 6 years, followed by 3 years. Total 14 years in the penitentiary, but counts of 7 and the merged counts of 8 and 9 run concurrent to count 1, a total of 14 years in the penitentiary. Mr. Vega, these types of cases end up everyone seeing a person who's basically a war hero, a patriot. He's someone who basically destroyed the family. And it's the same person. That's you, that's Randy Vega. So I sincerely hope that when you get out, and you will, that this is something that you follow up with, and you're helping educate other people. That's something that's small, driving under the influence, which might have made it more likely for you to engage in this conduct with Dr. McGinty. This tripwire has devastating consequences. I appreciate what you said, which seems sincere to me, to the victim in this case. When you get out, I hope that you continue to work yourself in the way that you have the first 40 plus years ago. Do I proceed? If 30 days of fire marshal. You gotta hear from the adult court.